Yes, Mr. Fry.
My lord, I'm Mr. Fry, act for the appellant, who is the claimant below. My learned friend, Mr. Tobin, acts for the respondent, who is the defendant below.
Yes.
My lords and lady, may I just check that the court has the relevant documents? There should
Yes.
be a core bundle, a supplementary bundle,
Yes.
and an authorities bundle. Those are the only documents.
Indeed.
Pay tribute to my
Is there a reason why we've been given transcripts of cases reported in the weekly reports?
No, not particularly, my lord. I understand that the weekly reports are the preferable approach rather than the citations. But no, my lord, is the answer. But I will note it. I'm very grateful. And I'm grateful to my learned friend for working to narrow the issues and authorities required for this appeal. My lords and ladies, may I take it that the court is familiar with the judgment below?
We've read the judgment below and we've read the skeleton arguments.
Okay. Grateful. Well, in which case, the court will be aware that there are really three issues that are being pursued in this appeal. The first being the meaning of issue in the civil procedure rules. The second being that even if the appellant is wrong on the meaning of issue, in fact, the claim form was not issued on the date of the seal, on which basis the factual finding that the claim form was not served in time was an error. And the third issue is simply the judge's discretion in applying CPR 7.63 was wrong in law. The court will have noted that there's a point raised in the application for appeal and in my skeleton argument at Article 6 of the European Convention. I'm not going to pursue that point today for the reasons given by the respondent in their resistance and because the point is actually dealt with obliquely in the authorities before the court in any event, so I don't need to advance that point, my lords and ladies. Turning to the principal ground, the nub of this first ground is that issued must mean something in the civil procedures rules. In the judge's formulation of the central question before him below, second paragraph of the judgment, core bundle 56, the judge accepts explicitly that the date entered onto the claim form by the court office was different to the date upon which it was sent out to the claimant for service upon the defendant. And I'll just turn that up.
Yeah.
And that's the central question in paragraph 2. At the third paragraph of the judgment, the judge makes a factual finding that the date entered onto the claim form was the 13th of December 2023, but the claim form was not sent out to claimant solicitors for service on the defendants until on or about the 2nd of April 2024. If the court will indulge me, this submission is perhaps one which will benefit from historical context, although make clear I'm not a legal historian and articulate this as a submission rather than evidence, but my submission is that the position is perhaps a historical acronym and a result of the rules of the court, not anachronism, and result of the rules of the court not catching up with the modern era, in the sense that for most of the common law period, the act of filing a claim was a physical act done in personam at a court counter. A person attended the court counter, filed their claim by handing it over, paid their fee, and that claim form was sealed and issued for service and handed back to that person. In that context, issue means simply no more than handing it back to the claimant with a seal on it. From that moment, the proceedings were constituted and the claimant was duly bound to serve the claim. The advent of electronic filing has had an obvious impact on that historical position. Now a person may file a claim electronically, and consequently, there is no immediate provision of the sealed claim form to that person.
But wouldn't the same problem arise if documents were sent to the court by post, which has been around for longer than electronic filing?
But potentially, my lord, but that is a point that I'm going to address shortly. But my lord's quite right. But historically, there was my lord will see my skeleton. The point I seek to make is that there is a transactional relationship essentially in the word issue.
No, I see that. I mean, I see that when somebody physically turns up,
Yes.
plastic bag full of papers and hands them over, and the court may or may not seal the form there and then. It may just put it on a pile of pending claims, but yeah. Anyway.
Well, I take the point, but whether by post or by electronic documentation, what happens is that the documents in the claim for sealing go into the electronic ether or into the court's management system, and at some point the claim is issued and sealed.
Yeah.
My proposition is that issued must continue to mean something as it remains in the CPR. There's no definition in the glossary of the CPR. As my submission is, it's always been obvious what issued meant. A bilateral transactional provision of a sealed claim form to the individual who filed it. There's nothing that certainly I have found in the authorities which supports the proposition that issued has some other legal definition quite apart from the normal everyday dictionary interpretation of the word, which I've set out at paragraph 34 of my skeleton argument, the action of supply or distributing an item for use, sale or official purposes. My submission is it simply never required, it was one of those words that never required definition, as it was a word that was so obvious that none was required. My submission is that if there was some magic in the word issued or issued, it would have been defined in the CPR or in case authority. And my lords, I take up my skeleton argument, my lady apologies, at paragraph 34 onwards, and I make the simple point that because it is my submission, a bilateral process, you have to issue a claim form to someone, you have to do something with it. You can't issue a claim form by in this case, placing a seal on it and putting it into an outbox or leaving it on a desk for a period of months without doing anything with it. That claim isn't issued, it's been sealed, it's been stamped, but not issued. And my submission is that the rules of the CPR and the correct interpretation of CPR 7.2 is precisely that. The claim form under CPR 7.21 is issued at the request of the claimant. And the purpose of that provision, my lords and ladies, is to make clear that it's not the court which is starting the litigation, but the claimant. And the rhetorical question I put into my skeleton argument, to whom does the court issue the claim form? It should have put in circumstances where the court itself is not serving the claim form, is the claimant. It must issue it to the claimant for service. That's the whole purpose of the rules. And CPR 7...
To whom does the court...
My lady, apologies.
Sorry, to whom does the court issue the claim form in circumstances where the court is serving it?
If the court is serving the claim form, then it issues it to all of the parties, my lady. It issues it to the defendant, but it takes upon itself the requirement for service. The claimant also requires the sealed claim forms because they are
So when is the point of issue then? Is it when it's posted to the defendant, when it's posted to the claimant? When on your submission is the document issued? Because you say it requires a bilateral, it requires a recipient.
And so, my lady, it is when it is provided or available to the claimant. It isn't
so not until it's received by the claimant?
No, not received, my lady. I wouldn't say received. I would say available or
well, available in what sense?
In the sense that it's on the court file and accessible to the claimant for service. I don't want to get into
Sorry, I
then
thought the
for-
question was what happens if the court
Yes.
serves the claim form. You said available to the claimant for service.
If the court serves it, my lord, it has been issued because it is a sealed claim
But
form that has
when?
been issued to the parties.
When? You see, this is what I'm trying to explore with you, Mr. Fry, because issue, I think you must accept that issue must mean the same thing, regardless of whether the court's serving it or the claimant's serving it.
Yes.
So your proposition is that in order for it to be issued, there has to be a bilateral transaction. It's got to be issued to someone.
My lady, I understand.
I then ask you, well, if the court is serving it itself, it isn't issued to the claimant for service in the same way as you have described. So at what point in time do you submit the claim form would be issued in that context, and why?
Well, my lady, I understand the point, and we're back to it's the submission I made in opening. Because it's bilateral, it's when it is sent to the defendant for service. That is the bilateral transaction.
So it's
The
when
claim
it's
form-
posted or it leaves the court office.
Of course, yes, my lady.
And if there are multiple defendants?
It would be issued when it is sent to when it leaves the court office, and it's available at that stage, my lord, to any defendant and to the claimant. I'll go into CPR 7.7 shortly, my lord, but the point is at that stage that the claim form has been sent out by the court. It is not sat on a desk.
Yep.
And the answer to all those questions about can I access the claim form, can I get it, can I ask the court for it, the answer would be yes, because it's been issued, it's sealed, it's been sent out. There is the proceedings have started in that respect. And on my lady's point, the proceedings will have started from the date that it is sent out from the court, because the parties agree, and again I'll make submissions on this matter, that the active issue is the starting gun for service. And one gets into CPR 7.6a and those case authorities where the court's been unable to serve, but following issue in that way.
Right. So does it follow then that Rule 7.2 is simply wrong when it says that the claim form is issued when the date's on the date put on it by the court? It's just wrong because it doesn't take account of the word issue.
I don't think that it's wrong, and we'll go into the authorities, particularly Walton and Pickering. But the purpose of those provisions, my lord, is to provide the date upon which the claim is issued and sealed, and the authority say you can't do both on separate occasions. So it's not wrong, but what I say is it's not determinative of the issue,
right,
because it is there as a reasonable assumption, or as the authorities have set out, the date of that seal must be the date of issue, because it can be nothing else. On which basis it's not wrong, but it's just simply not determinative in the sense that the judge below found it to be determinative.
Yeah.
Because as I said in my skeleton argument, that turns the relevant provisions on their head.
But it is a definition of issue. You said you couldn't find one, but the claim form is issued on the date entered on the form by the court. It's a pretty clear definition. That's its advantage, its clarity.
But well, that isn't a definition. That's capturing what the purpose of this seal is. As I set out in my skeleton argument, if that is the case, then it is extraneous drafting, because if all that is required to begin proceedings is the seal, then what is the point of the word issue? What does issue do in that context?
I think hence my Lord's question, are you saying it's wrong? And you say it's not, but you say it's not determinative. But there's nothing else in the rules that could help with that determination, is there?
No, my lord, there's nothing else in the rules. I'm saying, and my submission is that CPR 7.2 is not definitive or definitional in the way that my lord has set out.
Well, I think you have to say, Mr. Fry, that it doesn't mean what it says on its face, because your whole thrust of your argument is that a claim form is not issued until it leaves the court office. It's sent either by the court for the purposes of the court service, or it's sent to the claimant or his solicitors for their service purposes. And therefore you would expect the rules to say that a claim form is issued on the date when it's sent out by the court office. Instead, it says it's on the date of sealing, and it may well be, although in 99.9% of cases that is the same date, on the 100th occasion, as happened here, they're different. So I think you do have to say that 7.2 doesn't mean what it says on its face, because on the face of it, the drafters of the rules are saying, well, it doesn't matter if there is a discrepancy between the date on which it's sent and the date on which it's sealed. For the purposes of time ticking, it's the date of issue is deemed to be the date of stamp. And that has the advantage of clarity, although it may cause problems in certain cases.
Well, Lady, this is, I accept that this is a submission made in terrorem, but if the date is simply wrong, and accepting that it is wrong, it can't possibly be. If, for example, on the court seal by accident it says 2028 rather than 2026, the claim form cannot be issued on the date entered onto the form. It has to be something else, which is why my submission is that is simply to assist with identifying the date. But if it is simply wrong, as my secondary point of appeal is in this appeal, then CPR 7.22 cannot be determinative in the way that is set out. I understand that it is the general proposition, but my submission is that I made repeatedly, and I'll only do once more, is that it's not determinative of the issue in the way that has been accepted by the judge below.
You also, I think, would have to tie your submission in with Rule 2.6, which says the court must seal the following documents, quote, on issue, unquote, first of which is the claim form. Now, your submission suggests that the court seals the claim form before issue. At any rate, if it's left in somebody's out tray to post.
We'll look at Walton and Pickering, but the two actions take place at the same time, in that one cannot issue a claim form unless it is sealed, and one cannot seal a claim form unless it's being issued. That's the point about sitting in an out tray. What one can't do is stamp a claim form on a certain date, sit on it for, pick a date, my lord, anywhere between 3 days and 3 years, and simply say, well, it was issued 3 years ago. That is the core of the appellant's submission, that it's not for the court to cut down, or the court office to cut down time for service in that manner, and that's what the authorities say. So to the extent, if I'm wrong on my interpretation of 7.22 as not being determinative, then perhaps, as the court is driving me to, I have to say that the drafting is unclear, if I put it in that way. I don't say it's wrong because I don't say it's determinative, but if it is unclear and needs to be clarified, then that is a point for the Civil Procedure Rules Committee, not for me, my lords and ladies.
Yes.
Did you mean to submit what you did in answer to my lord a few minutes ago, that it can't be issued before it's sealed, and it can't be sealed before it's issued? I just want you to think about that.
My lady, I understand. Only sealed documents can be issued, and it is quite correct that in order to be issued,
It's got to be sealed.
it's got to be sealed. My lady,
That I see. It's
apologies.
the converse that I was worried about,
Yes.
because you were suggesting it could be
Can you
sealed.
issue and then seal?
Yes,
or to
and on
be-
your analysis that doesn't
No.
work, does it?
My lady, I'm very grateful. I confused myself.
Yeah.
Because in the old days, when the chap pitched up with the document at the counter, and the court staff, they'd bong the seal on and say, "There you are, mate." I mean that in the happy days when there was a counter service,
Yes, well,
that's how it worked. So it's seal and issue almost simultaneous, but seal first, I think.
that has to be correct, my lord, and it takes us back to the discussion we had right at the start, and I'm not sure we've got the relevant authorities, but you can't serve an unsealed claim form because the proceeding hasn't started, and you have to serve the actual sealed claim
Yes.
form to points to issue without the seal being on. So, my lady, to the extent that I
That's
can see
ideal
myself-
shopping. So
Ideal shopping, that's
yeah,
correct.
yeah.
Yes, there are oblique references to that case in the authorities, but we haven't given you ideal shopping, but that can be provided afterwards.
No, but that because there was the service of an unsealed claim form, and that wasn't sufficient. That wasn't proper service, and then there was the question because proper service didn't happen in time.
That's correct.
Yeah.
And then the authorities just absolutely, it can't even be a photocopy claim form,
Yeah.
it has to be the original claim form. So, probably a good time then to take up the authorities, if the court would do so. I can ask the court to pick up Rogers, which is at Authorities Bundle 12. Paragraph 36. And what the court is doing there, if one looks at the paragraph beforehand, we will go to Walton and Pickering as well, my lords and ladies, but essentially the commentary is about Walton and Pickering, which is a case where the Court Office lost the claim form, again submissions to follow on that point, but the point made at the penultimate sentence of paragraph 35 about reasonable steps. The steps had to be judged only once the sealed claim form is in the possession of the claimant. Just to note, my lords, the paragraph I wanted to take the court to was paragraph 36, which is about the inconsistency between what happened in Walton and planning statutory review cases, and the court held no inconsistency. In a standard service case such as Walton, the 4-month period for service does not start until the issue of the sealed claim form by the relevant court office. We can skip the next sentence. The sentence following, but the position in planning statutory review case is different because there the relevant period for service has been started not by the action of court in issuing the claim form, but by statutory provision which applies whatever the court does or does not do so. The court then analyses a case such as this where time starts running and then makes the point again, regardless, in a planning statutory review case, regardless of when the sealed claim form is in the claimant's possession. So my submission is that the court making a distinction there, noting that the 4-month period does not start until the sealed claim form is in the possession of the claimant, or is able to, as I said to my lady, I would submit available to the claimant.
Sorry, where does it say that?
My lord, paragraph 36. You have at the bottom of 35 the reference to the sealed claim form being in the possession of the claimant, and then the penultimate sentence of paragraph 36. It's discussing the position in a planning statutory review.
Yes,
my lord,
well, that's certainly
where
clear
time started.
that time starts when the statute says it starts, but where, I thought you were saying that this supports the argument that under the CPR, time doesn't start until the claim form is in possession of the claimant, and I'm not
Yes.
sure that I see that
Might not
paragraph
understand.
36 says that, and indeed footnote 2 suggests the contrary.
My Lord, I'll address footnote 2, but the first point my Lord makes is I was drawing the court's attention to the second sentence of paragraph 36, the standard case, the 4-month period, starting until the issue of the sealed claim form by the relevant court office.
Yes.
One then reads down.
That then begs the question of when. When is it issued?
Well, my Lord, the answer or the point of distinction that my Lord, Lord Justice Coulson in this case made is that in planning statute review, the penultimate sentence, second clause, regardless of when the sealed claim form is in the claimant's possession, my submission is that there's an indication there that what's important.
That's because that was relevant to Rogers.
It was, my Lord, but the point of distinction is that what does it mean to get it into the claimant's possession?
But you've got to look at this in context, Mr. Fry. Paragraph 35. The issue in that case was how do you, which period do you look at for the purposes of Rule 7.63b on the taking of reasonable steps? And the
Yes.
Deputy High Court judge had said only once the sealed claim form was in the possession of the claimant, which seemed to be inconsistent with cases, says my Lord. And then he comes back and says that in the context of the planning statutory review there isn't an inconsistency, and explains why. So the focus on something being in the possession of the claimant was not to do with the time for service of the claim form, it was to do with the taking of reasonable steps to serve. It was a different part of the rule that was the focus there.
I understand, and my Lord will understand why I pleaded the various grounds of appeal in the way I have, because
Yes.
that goes to my subsidiary
that's your
grounds
third
of
point.
appeal. But I can see the court not with me on the argument that there is an analogy there to be made between the between start, issue, and possession. But I will see if I can get to it another way. Can I go forward in the bundle then to Walton? Authorities bundle 88 is the reference I have. But actually I will start to put on 23. Well, because of its importance, and lady, if we start at the beginning, 83 of Walton and Pipping, which I know the court is well aware of. It was a case where the court office lost the claim form. Paragraph 14 on Authorities Bundle 86 sets that out. In that case, Mr. Walton received a copy of the claim form on the 7th of December 2020, but the date of the seal was some months earlier, 20th of July 2020, and no one knew when the seal was applied. Paragraph 16, the last sentence, the court sets out the facts that Mr. Walton he paid the fee, he didn't receive what he was entitled to, and didn't get the issued claim form for many months. And when he did, it was too late for him to serve, as it bore a date of issue 20th of July 2020, and he did not receive it until 7th of December 2020, when it was already ceased to be valid.
I mean, the key point in Walton, sorry to interrupt Mr. Fry, but paragraph 14, the key point is that on the evidence in that case, it was absolutely plain that the seal was placed on the claim form at some point between the 30th of November and the 7th of December, but the date that it stated was the 20th of July. And that, as I recall, was common ground between the parties in Walton. I say that because I seem to recall that I was the judge who let it through on PTA. I wasn't part of the constitution that decided the appeal, but my recollection is that it wasn't even an issue when it came before the court that was the case, and indeed paragraph 14 makes that finding. So you've got a situation where on the evidence before the court it is absolutely plain that it's been backdated.
My lady, again, my lady will realise that those are my submissions in respect to my second ground, and we are, I'm sure we'll go into that in due course. But as we're in Walton, it probably makes sense then for me to draw the relevant paragraphs to the court's attention and make the submissions that I wanted to make on them. So if the court looks at paragraph 23 onwards or 22 onwards, that is dealing with the CPR 2.6 point that we've been discussing already this morning, the definition of seal, what's to be done, and the claim form. And at paragraph 24, the court records Mr. Turney's submission about sealing and issue of the claim form being a single act that takes place at the same time. No express power to date the claim form on any other date than the date of issue. And the point that I was trying to make, my lords, in respect to 722, it's not to be read as conferring a discretionary power on the court to enter some different date on the claim form, but as requiring the court to enter the date on the claim form is in fact issued. That's the last sentence. And
this is all under the heading of backdating.
That's right.
Because that's the issue. Issue 1, ground 1 of appeal, backdating the claim form.
That's of course true, my lord, but these are points of general principle as well in terms of interpreting.
They're not. They're dealing with the backdating of the claim form. We always have to be careful. Judges set out headings so people know what the point is that they're addressing. This is addressing backdating. In that case, as my lady's pointed out, the court backdated the claim form. The court has no power to do that, this court said, quite rightly.
Yes.
And that's what all of this goes to. I appreciate you're coming on to deal with, you have a case that says that's what happened here, but we're not dealing with that at the moment. At the moment, we're dealing with your first argument, which is that issue is, I think, when it's sent out by the court, whatever date that may be.
Yes. But, my lord, I absolutely take your point, and I understand why my lord has made it, but my submission is, for example, paragraph 25 deals with the point that my lady canvassed with me earlier. Proceedings are not started until the court issues the claim form. On issue, the court must seal the claim form. Those are points of universal. That is not only dealing with the issue of backdating, my lord, but I actually understand why my lord makes that.
In which case, what Lord Justice Newgee should have said in the last sentence is, until the claim form is marked with a seal and sent out by the court office, the document has not been issued.
Yes.
Is that right?
Yes, my lord. Or so until the claim form is marked with a seal and it's not been issued.
And I think the same point arises on paragraph 28.
Yes, my lord, that was the next paragraph I was going to.
Yeah.
The actual date of issue, when it's been issued, and hence proceedings have been started.
Yes.
And the rules require, last sentence, my lord, the rules require the court to enter the true date when the claim form was sealed and issued, rather than a false date.
Yes.
I don't think there's any disagreement.
But earlier on in that paragraph, he says that the purpose of sealing the claim form is to indicate it has been issued. And the purpose of adding the date is to indicate when it has been issued, hence when the proceedings have started. But again, you would qualify that by saying, well, that's not determinative, because if the court hasn't sent them out, then the proceedings still haven't been started.
Yes. My lord, the point I'm going to go on to, again, taking of course my lord, or just Coulson's point about what the court is discussing in this paragraph, is that the paragraphs 29 onwards in Walton Pickering, they're discussing the purpose of the seal and of issue. And it's agreed between the parties that it's the starting For service, so paragraph 29, the only reason for identifying the submission was made to the court, apologies, that the only reason for identifying the date of issue on the claim form under the CPR is to start the time running for service.
I'm still worried about paragraphs 24 and 25. If one goes back,
My lady.
second sentence of paragraph 24, there is a submission by counsel for Mr. Walton. The rules treat the act of sealing the claim form and the issue of the claim form as a single act which takes place at the same time. Right, so on the face of it, that's a submission. And then Lord Justice Nugent says in the first sentence of paragraph 25, I accept these submissions which seem to me to be well-founded. So Lord Justice Nugent has said in terms that the rules or he's rejecting any suggestion that the rules countenance the possibility that the issue of the claim form occurs at a different time from its sealing.
Yes. My lady, that
And that is dead against your proposition, isn't it?
Only to the extent, my lady, that I've tried inarticulately to set out that it's the other way round, in that the seal is telling you when the claim form is issued, and that is the purpose of it, and that is, in my submission, how the rest of these paragraphs run, in that the whole purpose of the seal and the date of issue is for time to start running for service, and we'll have dealt with that in paragraph 28 and 29.
Yeah.
My lady will see at the bottom of paragraph 32 as well, the same. The primary function of the date of issue is the beginning of the period for 6 months, the case may be, the service of the claim form. And then if my lady turns over leaf, you have paragraph 33, and accepting, of course, my Lord Justice Coulson's point about what this analysis is about, which is clear from the first sentence of 33. The rules shouldn't be interpreted as permitting the date of issue to be backdated. The purpose of putting the date of issue on the claim form is to mark the beginning of the period of service. And then, if the court looks at paragraph 34, that is a key paragraph which I rely on. I do not think the interpretation of the rules that permits this to happen, i.e. the period of service to be condensed, should be adopted unless there's some compelling reason why the court should have the power to cut down or even eliminate altogether the claimant's period of service in this way. The court will have seen in my skeleton argument, I deal with the simple sequence point that Lord Justice Nugent addresses at the bottom of paragraph 34 in terms of identifying where the gap is in this case. And the gap is not, as in Walton and Pickering, between 1 and 2, the taking the claim form to the court office and sealing and issuing, but between sealing and issuing. So I've entitled that 2A and 2B. And I adopt gratefully the reasoning at the end of paragraph 34. There's no reason why that should be treated as abridging or enabling the court to abridge, let alone eliminate altogether the period between 2 and 3. My submission being there's no reason why 2A and 2B, there's a gap there, that should be treated.
That presumes that issues means what you say it means.
No, they don't accept that.
Otherwise, the gap is between sealing and issuing on the one hand and sending out for service, which is another. And that doesn't in any way affect the time for service. It just means that, unfortunately, the time for service may already have expired by the time it's received, in which case one then has to look to see whether or not it's a proper case for extending the time.
Yes, maybe I'll address the court on whether or not it should be the default position that sort of application needs to be made on issuance of a claim.
I don't think, Mr. Price, of any materiality, and I don't think it affects any of your submissions, but just going back to 30, 31, 32, one completely understands that there is the, as it were, the protective rule that if a claim form is sent to the court office but issued after the relevant date for limitation, you take the date that it was sent to the court office, as here. And one understands that of course is designed to deal with any delays which may not be the claimant's fault at the court office.
Yes.
But those cases often give rise to debate about whether it was sent to the court office in time. I'm sure you've seen those yourself. So the date of issue is generally significant for limitation purposes. There is that exception, but subject to that, usually when people talk about when proceedings were started, they look at the date the claim form was issued.
Yes.
So it is significant for limitation purposes. It's not a comprehensive answer.
Well, as I understand it, the date of filing is the important date for limitation purposes.
But usually people are filed in good time and it's issued in, and that's that. And people look at when the action started, when the proceeding started, by looking at the date on the claim form.
Yes, that's correct, Mel. Because
So-
what one can file in
So if you have a
maybe
later,
nearer.
so if you have a later debate about, let's say, whether some amendments raise a new cause of action outside the limitation period, you go back and look at the date on the claim form.
Yes.
Generally speaking. So I think, I'm not sure I agree that it's insignificant for limitation purposes. It's not a complete answer. But as I say, that's just thinking out loud, and I don't think it has any effect on your submission under ground one.
My Lord, I'm grateful. I understand that point.
Yeah.
My Lord, I will make my, if I could make, I understand the court's position. I'd like to make my submissions on CPR 7.7.
7.7.
7.7, and just say that, to show that they are illustrative of the point that I'm trying to make.
Yeah.
The wording of the provision, and respectfully, is illustrative of the point that I'm seeking to make. CPR 7.7.1 presupposes that where a claim form has been issued, it's in the control of the claimant, noting the sanction in the rule that the claimant must serve the claim form or discontinue the claim. It says where a claim form has been issued against the defendant but has not yet been served on him, the defendant may serve notice on the claimant requiring him to serve the claim form or discontinue the claim within a period specified in the notice. There's an implicit assumption in 7.7 that on issue the claim form is in the control of the claimant. If the claim form doesn't have, if the claimant doesn't have the claim form in its possession and indeed is unaware of the issue of the claim form, the response to any application for service of it wouldn't be an application to the court, as my learned friend suggests in his skeleton argument. It would be a simple response that the claim form has not been issued and therefore the application has no merit. What would apply?
You might make that response at one's peril, because if you don't know whether it's been issued or not, one might expect the reasonable person receiving a notice in relation to service to pick up the telephone to their opposite number and say, why have you served me with this notice when, as far as I'm aware, the claim form hasn't been issued? Defendant solicitors may then say, well, we rang up the court office and we were told it was issued, in which case you ring up the court office find it's issued, and make any application at that stage for an extension of time that you see fit. What's wrong with that? I mean, I can well see that a complacent solicitor might say, well, I don't know why you're serving me with this. I haven't seen hide nor hair of a claim form, and as far as I'm aware, it's not been issued. But it's a risk, isn't it?
My lady, that is true and that's right. And again, my lady's preempting the submissions I'm making my remaining grounds.
Yeah.
This is a case where the appellant was in correspondence with the court, was providing unsealed documents, and was sending emails to the court saying, please will you provide me with a sealed claims form? And the court didn't respond for many months after the court asserts on the seal that the claim form was issued.
But the difficulty is there was no communication with the defendant. As I understand it, the first time the defendant became aware of these proceedings formally was when they received the application for relief from sanctions.
But my lord, the defendant was aware of the claim more generally. There's correspondence.
More generally, I gather there was a letter of claim, although I couldn't find that in the supplemental bundle. There was a letter of claim in the middle of 2023.
That's correct.
But from December 2023
yes.
onwards,
Yes.
there was no, as I understand it, there was no communication. Certainly none is referred to in the witness statements from the solicitors for the claimant. No communication with the defendant until they got the application for relief from sanctions. And so obviously that is dead relevant to ground 3, but looking at 7.7, if the defendant had been aware that there was at least the potential of the claim form having been issued, they might have been able to take steps, as it were, in collaboration with the claimant under 7.7. But since the defendant was never told, they couldn't do anything under 7.7.
Well, that is true, my lord, but as I've set out, the judge made a factual finding below that the appellant claimant had no knowledge of the existence of the sealed claim form until the 2nd of April 2024.
But was aware that a claim form had been issued because of the claim number.
Well, no, my lord. I mean, I'll make submissions on.
Right. Well, we'll come to that.
On that in due course. I understand my lord's point.
Speaking entirely for myself, my principal concern is that for 18 months this was kept close, to the extent that it was being dealt with at all, to the claimant, and there wasn't what I would have expected, which would have been a more collaborative exercise.
My lord, I understand that, and I also understand that that's difficult for my case. My submission, I'll make it now and make it clear, is that if I'm successful, it goes to, it's a discretionary remedy or a discretionary order to extend time, and those are matters that the court might take into account in the exercise of its discretion. But the principal points that underlie this appeal are points, apologies for the tautology, but are points of principle which have application whether or not that 18-month, whatever happened in that 18-month period. And my lord, in due course, if I'm successful, I will take my lord through the various bits of correspondence. But I absolutely understand my lord's point. I understand that it is a difficult point for me to get around given that length of time. I'm just saying if there's anything else that I can say in respect of that first point.
But in essence, Mr. Fry, you want to draw an analogy with what happened in Walton, don't you?
Yes,
Yes.
I do, Melanie. And I also, I think the final point that I can realistically make on this ground is this is a case where there is a significant period provided for service following issue. The starting gun starts and there are 4 months to serve the claim form. But in other areas of litigation, those time limits are far condensed. There's a reference, I don't intend to turn it up for the court, but in Rogers, paragraph 19, Authorities Bundle A, there's a reference made to claims under the Public Contracts Regulations 2015, where a claim has 30 days to be issued and then 7 days to serve it. In circumstances where it is the case that a claim can be issued without being at least notified to the claimant that that is ready for service, which hasn't occurred in this case, there is a significant risk that the claimant is cut out of access to the court if they can't serve in time. And on the analysis carried out by the judge below, because in the case of a public contracts regulations claim the court had issued, the analysis of the judge below is that you wouldn't be able to avail yourself of 763B because you haven't taken all reasonable steps, even though you have no knowledge that the claim has been issued.
So in a nutshell, your submission on this ground is that the claim form is issued when a sealed claim form leaves the court office.
Or is available to the claimant, my lords. As I said, I appreciate that time has moved on, but as I understand matters in normal proceedings, a notice of issue is sent to a claimant to notify the claimant that the claim has been issued. None of that happened in this. Indeed, the only reason the claim form was shaken out of the court office in due course, as my lord and lady will have seen from the correspondence, is that the complaint was made by instructing solicitors and it got escalated to a manager and it got emailed to them they got an email on the 2nd of April 2024 saying, we're terribly sorry, but we're going to send you the claim form now.
Well, sorry, you said the date of issue is when the sealed claim form is made available to the claimant. But as my lady put to you, what about service by the court? In that event, it will be what? When it leaves the court office?
Well, it would be available to all parties once the notification is sent. So, yes, in a nutshell, I would have to say it's when it gets sent or provided or emailed or by whatever.
But is a defendant notified otherwise than by service of the issue of a claim form?
I don't know, my lord. I will look when I sit down. As I understand it, it is simply sent the claim form, but I'll need to double check that position. My learned friend might be able to help when he takes his view. But I don't believe that a separate notice of issue
No,
is
I'm
sent
not.
to
I didn't think so. I mean, I think the
But
first thing the defendant knows about a claim is service.
when it lands. Absolutely, my lord.
That makes it very difficult for the defendant to know whether he's been served in time, because the defendant doesn't know at what point in time the court office posted, let's say it's posted, the claim form to him. And let's suppose that one's up against, or one's outside the limitation period at this stage, and the claim form has been lodged with the court office for issue and sealing on the last day of the limitation period, as it happened here. And then the court office is responsible for service, so the court office issues and seals it and sends it out. Well, what if it posts it more than 4 days before? Sorry, what if it leaves it and sends it out late, as it did here? I'm just trying to work out how the defendant knows whether he's been served in time, whether he's been validly served. If you're right.
No, quite. And that is, I accept difficulty. And
it's a recipe for uncertainty. And the judge says one of the advantages of looking at the rules and reading them as what on the face of them they seem to say is that it creates certainty. So everybody knows exactly when time starts for service. The date on the face of the seal.
Yeah, yes, my lady. I understand the point my lady makes, but my lady has my submissions as essentially that's rebuttable in the sense that if it is not the case that the seal, taking Walton for example, is the date of issue, then the uncertainty is already there. And indeed, my lady, that point cuts both ways, in that if it were a claim that the court was to seal, similarly, it might be sealed and issued by the court on a certain day, not sent for weeks. And again, the defendant has that uncertainty because the court has failed to serve in time. So,
well, on your case, have failed to issue it.
yes, my lady, and I appreciate that creates keep using the word issue, a problem in the rules that requires clarification. And I think my case is that it is not clear, my lady, and that would be assisted by definition of the meaning of issued. And you have my submissions on what I say issued must mean in the context of the CPR.
Yeah. Right. All right.
I'm very grateful. In which case, I'll move on to my second ground of appeal, the factual findings. And the judge held that the appellant essentially ought to have known that the claim form had been issued on the 13th of December 2023. And the reason given was that the claim had been given a claim number. And that reasoning underpins my learned friend's submissions before this court in response to each of the second and third grounds. The submission essentially is that a claim number means that the claim has been issued. But, my lords and ladies, there's nothing which indicates that the claim number is tantamount to issue. In Rogers itself, at paragraph 60, Authorities Bundle 17,
Sorry, Mr. Fry, I'm behind you. We're going to Rogers.
Rogers, Authorities Bundle 17, my lord, paragraph 60.
Yeah. Yes.
Very short point, but well, this court noted that a claim number will be provided by the court office on the making of an application for extension. Doesn't necessarily indicate that a claim has been issued. And well, to go one further, that the fact that the claim number isn't tantamount to issue can be shown on the facts of this case in particular.
Do you really mean isn't tantamount to issue, Mr. Fry? Sorry to pick you up on the language, but nobody's suggesting that the application number is tantamount to issue. What's being suggested is that the existence of the claim number is indicative that a claim form has been issued. And I think your submission is not necessarily, because look at Rogers at paragraph 60, where it suggests that it may occur before that time.
Yes, I mean, Melly, it is not determinative of whether or not a claim has been issued.
Yeah.
Which
Oh,
is...
sorry, let me just think that one through.
Of course.
The court is not going to put a claim number on anything unless somebody makes an application to it, of one kind or another.
Yes.
And in Rogers, the contemplated application was an application to extend time even before the claim form had been issued. And I imagine that in order for the court administrators to know where to file something, they need to give it some means of identification, which would be a claim number. But if the only application to the court is the sending of a claim form for issue, what else could the court mark? On the facts of this case, what else could the court mark with a claim number except documents that had already been sent to it?
Well, look, I understand the point. And the answer is I'm not sure what else the court had within the context of the claim. There was a help with fees application and things like that, which might have created it, but I don't know enough about the court system to be able to make that submission to the court. But there were, as I understand matters, other applications that were involved in respect of fees. But I don't necessarily.
Except those had been, on the facts, am I right? Those had been resolved by December.
Or were resolved, as I understand, matters on the 12th of
Yes.
December, my lord.
Hence the receipt for the money and the first reference to the claim form. So you're quite right. There was correspondence about the help with fees point, but on the 12th they took the money, sent the receipt, and there's the claim number.
That's correct, my lord. And that was on the 12th. So the claim number was assigned to the claimant at some point then on the 12th or prior to the 12th. But of course, the claim is sealed on the 13th.
Yes.
And also
And I think we could forgive a day between issue and sealing, if that turns out to be the point. I mean, yes, they should be simultaneous, and would have been if the man had come to the counter, but there aren't any counters. So, but the short point is that there was a claim number then.
Yes. There was. I mean, that was the point I'm afraid I was going to make, my lord, that there was a claim number in existence before this claim was sealed and on the
Yes.
Well,
on
it may have
the
been
judge's
a few hours,
finding
it may have been
issue.
a few hours before. But the question is, here, does that claim number signify anything or not on your submission? Are you saying that the fact that a claim number is assigned is completely neutral in this context? Or does it indicate that if a claim form hasn't already been issued and sealed, it's going to be imminent?
My lady, my submission is it simply indicates that the court has opened a file.
So it's neutral.
So it must be neutral. That has to be the outcome of my submissions.
Yeah.
But notwithstanding those submissions, it is, in my submission, difficult, if not impossible, to reconcile a duty upon a claimant to know about the claim form being issued in circumstances where accepting the claim number has been identified. The court itself appears to have been unaware that the claim form had been sealed and issued.
I'm sorry to interrupt again, Mr. But I'm just looking at the facts here.
Yes.
There was an application for the help with fees point,
Yes.
and a different reference number was given for that, was it not?
My lord, are you in the supplementary?
I'm looking at, for a start, the supplemental bundle page 28, where we've got a reference number HWF-NNEWQ7.
Yes.
And that reference number is repeated on page 29, and then again on page 30. So when you suggested that the K number might have been a reference number for the help with fees application, that would seem to contradict the fact that it had already been given a different reference number beginning HWF, which presumably stands for help with fees.
My lord, I'm grateful. I'm very grateful I qualified what I said about help for fees as well. There is a different number. I can see that, my lord.
Yep.
When I sit down, I'll see if there's anything else I can add to
Right.
that analysis. But my lord, the answer is I don't know. I don't know when the claim number was given. I can go through the correspondence, see where it first
Yeah.
appeared. My understanding is that it first appeared on the receipt that was given in response to payment on the 12th of December. But
Certainly looking through the documents, I couldn't find any reference to that number prior to that date.
yes, my lady, I think that's correct, and I'll just double check.
I think Mr.
The point.
Labour agrees.
Nodding vigorously. Vigorously. Going back then, my lord, to the submission I was making, the point about the court itself being unaware, despite the existence of a claim number, that the claim had been issued and sealed on the 30th of January 2024. The court has that at Supplementary Bundle 283.
283.
283.
Yeah.
My lord, will, and I've noted, given my lord's comments, that there's no reference to the claim number on this letter. But
This is still dealing with help with fees.
yes, but my lord, the point I'd draw the court's attention to is that the last penultimate paragraph.
Yeah.
Please resubmit both the fee and new issue documents for processing. We're unable to take your contribution fee without your claim form to process.
They'd already taken the
They'd
fee.
already taken.
They'd already taken it.
So the letter was clearly an administrative error, to which you write back and say, we've already paid this fee, see the receipt, blah, blah, blah.
Which is exactly what my client
Yeah.
did. Well, but the point I seek to make is that the court wasn't aware that the claim had been issued as on... the
Well,
30th
this
of January.
bit of the court,
This was the HWF.
I mean, it
My lord,
help with fees is doubtless a different department in the labyrinth that is Northampton
It's the CCMC.
to the sealing issuing element. I mean, I think that would be my, if I was the solicitor and I got this letter, I would roll my eyes, I would complain about HMCTS and their inefficiency, which would be entirely justified. But I think this looks like an error. I mean, your submission is, well, it doesn't refer to the claim form if, the claim number, and therefore that suggests that the claim form hadn't been issued. That's your submission.
and there's, my lord, there's a response from my solicitors, exactly what my lord canvassed. I think it's in the judgment. May I just check the judgment, my lord, just to make sure that I can take the court to the factual finding. Yes, my lord, paragraph 6, G of the judgment, core bundle 59. On 21st of February 2024, the claimant solicitor sent an email to CMCC in response to the letter of 30th of January 2024. The email included the following: we've already sent the court forms for issue, but for your convenience, this is, I think the not is an error, attached again. Kindly issue 3 copies and return to our office. Please note, claim number has been provided and it's given. We spoke to the court yesterday and were informed that there had been a court error because the payment line did not update the records to show payment has already been taken by the court and the matter should now be expedited. So,
Yeah.
my lord, my solicitor did exactly what my lord has just canvassed with me and wrote, and there was no response to that email saying, "Oh, we're really sorry, we've made a mistake. We've issued it, and here it is. Oh, by the way, the claim form was issued on the 13th of December 2023. What the record, or what the email from my solicitors say is that they had spoken to the court and the court made an error and the payment hadn't been put on file. And my submission would be the payment hadn't been put on file. It may well be that the claim wasn't issued on the 13th of December as suggested, because without payment, the court would be well aware the court wouldn't issue the claim form if it wasn't paid. And what is being captured there is that the records didn't show that payment had been taken. So it is, in my respectful submission, an important point, because it shows the error and it goes to my formal position, or my position, that the claim form was unlikely, frankly, to have been issued on the 13th of December. because the payment hadn't been taken, or the court wasn't aware that the payment had been taken, and certainly in this
Well, the records hadn't been updated, is what was said.
Yes. Yes, my Lord, I take your point that CTS is a big department with different issues, but my Lord held against me in Rogers that one needs to take it as one indivisible.
Yeah.
So you're right. It may well be an error by one hand, but it's not an error in my respectful submission. The claimant ought to be wearing rather than the court. And that analysis and that exchange of correspondence goes to my submission that the judge's reasoning in his judgment, paragraph 19, there was no evidence that the claim form in the present case was backdated, which meant Walton could be distinguished, doesn't bear scrutiny, because on facts of this case, the court was still asking for the claim form on the 30th of January and didn't receive it until the 21st of February. May I just turn my back really quick? I just want to check one thing with my... Not saying... Apologies. I just want to check one factual matter, but it doesn't necessarily... My submission, and of course I've taken my Lord's point that this is simply an error in different hands, is that there is evidence that the claim form may have been sealed on a date after the 30th of January 2024, because the letter says the court didn't have the claim form to process.
But it did have the claim form to process. It had it since December. I mean, it was. That's what keeps you within the limitation period. If it didn't have it to process, you'd have been well outside the time for limitation purposes. You have to rely on the fact that it was lodged with the court office at a time well before that. In fact, over a year before this whole debate.
But, my lady, that was the position in...
I mean, this is the real problem. The real problem is that there was this huge hiatus. It was lodged with the court office at a time which was within the limitation period, just last day. And then there was a hiatus of a very, very long time whilst there was toing and froing about help with fees and payment of the court fees and trying to process the court fees, part of which was the problem with the CCMC, for which your client can't be claimed in any way, shape or form. So there were 3, as I understand it, abortive attempts to pay the fee. Finally, over a year after the papers have been put with the court office, about a week after a year, you get a receipt for money. The money's gone through. That's the last obstacle to issue and sealing. And then you get a claim number assigned. And then after that happens, you get this missive at the end of January suggesting that they haven't even received the claim form. Well, you know at that stage that they received it a year earlier. So it makes no sense, does it? That letter?
My lady, it only makes sense if the court office has misplaced or lost or done something otherwise with the claim forms that were submitted. In terms of limitation, it was the point that was canvassed in Walton but never addressed because Mr. Turney didn't have time to deal with the point about limitation. It was exactly the same point, my lady. It was raised in Walton and wasn't addressed by the Court of Appeal in that case. But, my lady, as I've indicated, there is correspondence and it's captured in the judgment and the judge has made factual findings. There's correspondence between the court and my instructing solicitor on various occasions in February, March and April, and as I've already submitted, the claim form only was dislodged from the court following a complaint. So if my submission has to be that the court may have misplaced the claim form and needed it, on the 30th of January, then that is my submission, my lady, because that is what that's what the analysis of the letter and the response from my clients suggests. In terms of limitation, then yes, it would be a matter of, did my client file within the limitation period? That is agreed between the parties, but the court then lost the documents that were filed and seeking to repair that loss. Then that is my submission, certainly one outcome or one interpretation of the correspondence in early 2024.
Well, it doesn't have to have lost it. It could be sort of misplaced somewhere within the office. But that doesn't mean to say it wasn't sealed and issued on the date that it bore. I mean, it's equally likely, isn't it, that it was sealed and issued on the date that it bore, because the last obstacle to seal and issue, which was payment, had actually been processed and a receipt had been given for it and a claim number had been assigned to it. And then, for whatever reason, which we have no explanation for, court office didn't post it out. It's just sitting there on a shelf.
Yeah.
But that doesn't mean it wasn't issued and sealed on the date that it bears, or that it was backdated. At the moment, I'm just trying to explore, Mr. Fry, why it is that you say that the judge's fact-finding is wrong, or at least it's so wrong that it's open to challenge in this court on the time-honoured principles that we're all well aware of, as to how the judge at first instance evaluates the evidence before him.
Well, Melody, I'm not sure I can make the submission in any different way, that essentially the judge found that this wasn't a Walton case of backdating. My submission has to be that the evidence shows that my submission is that it was. But at the very least, my lady, it's a position where it may have been. It was something that the judge ought to take into account, because...
Well, if it may have been, does that get you home? Because you've got to show that it was.
Well, because we will then go into ground 3 and the exercise of discretion, Melody. But I suppose that the point that I can make during this period is that my solicitors were in correspondence with the court at various occasions. They had the January letter, they had the February email. At no stage did the court office turn around and say, "Oh, we're terribly sorry, here's the claim form that was sealed on the 13th of December. It was only on the 2nd of April, as I've said repeatedly now, my lady, following a complaint and escalating to managers and so on and so forth, that the sealed claim form was emailed, reference to the claim form was emailed to my client, letting them know that the claim form had been sent, and then it was received on the 15th of April.
It looks as though you're instructing solicitors were in contact with the court about once a month.
That appears
in early 2024.
Well, look, absolutely, and as I've accepted that may be a point against me, but equally, my lord, at that stage, and the judge accepted it below, my clients didn't know that the claim form had been issued and was simply waiting. And my lord will see from the correspondence captured in the judgment, my client said, "Please will you issue the claim form?" So, in terms of knowledge, the judge properly and fairly accepted that my client didn't have knowledge of the issue of the claim form. But the point I make is the court at no stage in this correspondence on a monthly basis said, "Oh, here it is, sorry," until the email of the 2nd of April where they said, "Oh, sorry, it was an error, we're going to send it to you now."
Yeah.
Rose, I just want to address my lady, I just want to address the contention that the right way to deal with this would be an application under 7.6 if one doesn't know. And I made the point briefly in skeleton, but if you don't know that a claim form has been issued and you are not within the planning statutory review or other litigation context of you know that there is a statutory deadline for issue and service, the starting gun only starts when the claim form is issued.
Are we moving on to ground 3?
Not yet, my lord, because I think it is relevant to ground 2 as well.
Okay.
Perhaps it's addressed out of context, but it's more to illustrate the point, my lord, that if one is going to make an application to extend time for service of the claim form, my submission is, in the context of normal litigation where there isn't a statutory time limit, you have to know whether or not the claim form has been issued, because otherwise, and whether or not you've run out of time, because otherwise, do you make your application under CPR 7.61, which is a less stringent test than 7.63? If you're out of time, you're in 7.63, you need to show reasonable steps and promptness. If you're not out of time, you simply make an application with reasons to extend time. There are different tests, but...
Well, of course, here, your instructing solicitors didn't do either.
No.
I mean, their application was relief from sanctions.
That's correct.
They didn't make an application under 7.6 until November, I think.
That is correct. But the judge below did find that the test of promptness in terms of making the application, that there's authority to support the proposition that if one applies for relief from sanctions, the court can substitute 7.6.
Yeah, no, I understand that.
The judge below found that it was prompt in terms of knowledge of when the claimant discovered the date of issue, made the application promptly, but not prompt in terms of from the date of seal.
Yeah.
Well, how about this? I mean, you're outside planning statutory review. I take that point, but that doesn't stop you making a proactive application under the less stringent provisions for an extension of time. The one thing you do know is that the earliest date on which the claim form could have been issued in this scenario is either the 12th or the 13th of December, because that's the date on which the claim number has been assigned and the money's gone through. So at any point from that time onwards, the claim form could be issued. Taking that as the earliest point in time at which it could have been issued, then on the worst case scenario, your time for service will expire 4 months from that date. What's wrong with going to the court before that 4-month period expires, saying, we haven't got the claim form yet, there's been a lot of correspondence going backwards and forwards between the office, but there's a possibility it may have been issued, and just in case it has, and when we get it, we'll get it after the 2nd of April, we'd like an extension of time for service. And the court would probably say, well, yes, you're entitled to it because you shouldn't be kept at a disadvantage.
My lady's correct, but that would be an application made in anticipation of there being some issue, some problem with issue and receipt of the claim form. The position in December and in January and in February was that my client had no knowledge of the existence of the issued certificate.
The problem was that your clients were complacent. The solicitors assumed when they got the notification from the court in April that the claim form had just been issued and that they had another 4 months. That's what went wrong. It didn't occur to them that it might have been issued back in December when the notice was attached to it, the number was attached to it.
My submission with that was a safe assumption to make, given the correspondence that we've been through in those first few months.
But it gave rise to a risk. And at the moment, you're addressing us on, how does one know what particular limb you go under? Well, the answer is you look at the worst case scenario and you go for the worst case scenario. And if necessary, you make your application on alternative bases.
My lady, I take the point, but respectively, that relies on you knowing that the claim form has been issued or might have been issued.
Might have been, yes.
and it leads to a position, my lady, is again in terrorem, I've outlined in my scope and argument, that a competent solicitor then ought to make applications for an extension of time just on the basis the court might mess up, which seems to me not in accordance with the overriding objective in the rules.
Well, I take that point, but this was a very unusual situation because the claim form had only been sent on the last day. So everybody's antennae should be twitching that they were the last chance saloon in terms of limitation. And a period of 16 months goes past until they get the claim form back and they make an application for relief from sanctions and then notify the defendant. And you have to argue, I think, that the starting gun didn't go until, I think you say the 15th of April?
Yes, 2nd or 5th of April.
Because otherwise, if you're looking at the whole period, then you can see why the judge came to the view that he did.
Yes.
So do you say that the judge was wrong as a matter of law to have regard to the whole of the history when considering the application under 7.6?
Yes, I mean, that's my third ground, and I'll move into it then.
Well, I think we're into that, aren't we? Because I mean,
they're all parasitic moments from each other.
At least I was clever enough to see that when you were talking about when the starting gun went, that was probably ground 3. Or I appreciate it's relevant to ground 2 as well, but it's really relevant to ground 3.
Yes, that's correct.
Well, I think you say, don't you, if I've understood correctly, service of the time for service of a claim form under Rule 7.5
Yes.
is 4 months after the date of issue of the claim form. So until the claim form has been issued, see ground 1, the starting gun, the time period hasn't started. When you go to 7.62,
Yes.
that you should apply within the period specified under
Yes.
Rule 7.5. Within the period must mean after the date the claim form has been issued,
Yes.
because the period doesn't start until then. So that doesn't quite fit, because you can't apply under 7.62 because you're not within the period which ex hypothesi on your
Yes.
argument hasn't started. Nor actually can you apply it under 7.63
No, you're right, Mel.
because you're not applying after the period because ex hypothesi it hasn't started. So can you then apply under 3.9? What sanction? What sanction are you now asking to be relieved from?
Well, it goes to my lady's point, my lord. In circumstances where you don't know if the claim form has been issued or it may not have been issued.
Well, again, this is all dependent on your ground 1. If the claim form hasn't been issued because it hasn't yet left the court office or, in your alternative formulation, been made available to the claimant, there is no sanction against which you can ask to be relieved. So everything hinges, as I see it, on ground 1.
And my lord, I've accepted that the grounds are essentially parasitic or illustrative of the critical point. But my lord's quite right, and actually I hadn't thought about that.
Well, I understand that if ground 1 succeeds, that you are not, or you would not have been out of time because the 4 months would have kicked off on the date when you say it was sent to you, which is the 2nd of April, and then you would have served within that 4-month period. So you don't need relief from sanctions, you don't need any extensions of time, etc. If you're wrong on ground 1 that then does get to grounds 2 and 3, ground 2 I think is almost a self-standing ground because it said well, the inference should have been drawn that the claim was in fact sealed and signed at or close to a date which would still put you within the 4-month period for service, as I understand it.
Yes.
So ground 3 only applies if you're wrong on grounds 1 and ground 2, whereupon it was a 4-month period which ran from the 13th of December for service, and you were already out of time for doing it at or close to the date when the court office said it was going to send it to you. Is that right?
That has to be right. Absolutely.
And there is still a window, isn't there? Because as I remember it, it's the 13th of April and you were told on the 2nd. So if first class post had arrived, you would still have had about a week if it had arrived in the normal course of things. But we don't know why it was that the court office, having said they sent it to you on the 2nd, you didn't get it until whenever it was, the end of the month.
15. That's right. But of course, at no point was the claimant made aware that the date of issue and the date of seal was the 13th of December.
I am now going to ask you this question. If that analysis is correct, let's assume that it was reasonable for your solicitors in all the circumstances, let's say we accept your submission, it was reasonable for the solicitor in all the circumstances to believe that it had only been issued and sealed at the beginning of April.
Yes.
Then, do you say it was that it was entirely reasonable at that stage to sit back and think, well, we've got 4 months from the date we actually get it? Because that doesn't seem to me to fit in with the fact that the minute they get it and see the date on it, they start applying for relief from sanctions.
Melody, I don't understand, but let me.
Sorry, it's my fault.
No, let me.
It's my fault for not articulating the question clearly enough. I apologise. There seems to me to be an inconsistency with the position that you are adopting at the moment, which is we reasonably believed that it hadn't been issued and sealed until April, with immediately applying for relief from sanctions when you get it at the end of April. Because if you thought it had not been issued and sealed until April, notwithstanding that the date appears to be earlier, then you think you've got 4 months in which to serve it.
Oh, well, I mean, Melody, that's easily dealt with in the witness statements in the supplementary bundle. But essentially, my solicitor says he got the claim form, he opened it up, he had a look at it, he saw the date of the seal, which the date of the seal is the date of issue in the CPR, except all of that. Immediately panicked because he knew he was out of time, which is why he made an application. But the point I seek to make is before he opened that letter on the 15th of April, the claimant had no knowledge that this claim form had been issued. So it isn't a case where the starting gun, so far as my clients were aware, had started, on which basis, as my lords just canvassed, it's difficult for me to understand what application they could have made before they realised what the date was on the claim form to extend time, because my client's position, and accepted by the judge below, was no knowledge.
The difficulty with that is that means that in this case, the limitation period, instead of being 3 years, was well into its 5th year. And that just can't be right. How can the defendant be deprived of what was a clear limitation defence? That you have to look at that, don't you, when you're looking at what happened from the 2nd of December 2022 all the way through to April 2024. I mean, that's my difficulty with your starting gun point. I mean, I understand why that's your submission, but it's a starting gun that goes when the vast majority of the delay, about which the defendant knew nothing, has occurred.
I understand and take the point, but suppose all I can really say in response is that had the claimant known that the claim form had been issued on 13th of December 2024, apologies, my lord, and served it shortly thereafter, the claim would be properly constitutional live, but we would not be having this argument, my lord. So the delay is significant, but that doesn't defeat the claim which was filed for the purpose of limitation within time, which is agreed. The only reason why the court declined jurisdiction was because of the extension of time point, as opposed to saying it's taken you 16 months to get to this stage, that's why this claim dies on its feet. Had it been served any time before the 13th of April 2024, the claim would be liable to proceed in the normal way and be set directions.
And that's because the rules are deliberately designed to protect a person who files on the last day against any delays within the court office system. I mean, this may be an exaggerated example of it, but because it's thought that that sort of delay is not to be laid at the feet of the claimant, then all the toing and froing over help with fees and all that sort of thing, that stage, is irrelevant. If you had served, if you'd got it and you'd served it within the 4 months of the December date, then all would have been well.
That's
For limitation purposes, notwithstanding that the effect of it, practical terms, is to extend the limitation period by up to another 2 years.
I agree absolutely.
That's your point.
It's a function of the rule. It is how the rules are constituted. Yeah. There's nothing. I take, of course, my lord's point, but that is how it works, and that is the point. Had this been served in March of 2024, there would be no argument as to limitation or to whether or not the court had jurisdiction. My lord and lady, I think I can be relatively brief with ground 3 in that context, in that it is parasitic to an extent on ground 1, but under CPR 763B, in considering an order to extend time, the court can only make the order. You only get through the gateway of making that order if the claimant has taken all reasonable steps to comply with Rule 7.5. Has been unable to do so. We've already looked at CPR 7.5. The claim form must be issued and the date of issue starts time for service of that claim form. We've already canvassed that only a sealed claim form can be served, and a claim form without a seal has not been issued and any service would be ineffective. So my submission is that until the claimant has an issued claim form and has access to it, the claimant cannot serve it or take any reasonable steps to serve it.
They can't formally serve it, and that's ideal shopping, but
yes,
they can and could, in this case, have provided a copy to the defendant 15 months before. I mean, there's no magic in the words of the claim form. It's a very short claim form.
Yes.
And it had been sent to the court office such as to arrive on the 2nd of December 2022. From then until, let's say, the 2nd of April 2024, it could have been provided under cover of a letter which said, we've got difficulty with the court office, if that's what the perception was, with issuing this claim form because of problems with help with fees. But this is the claim form, we sent it on the 2nd of December. I mean, it's always difficult to put yourself back in the position of the judge at first instance, but put it this way, if I'd been the judge at first instance, that would have been a tick in your box.
Yes.
And that goes back to the point I was making about the claimant keeping it all close to his chest, her chest.
My lord, that's understood. The issue is, as just canvassed, that service of an unsealed claim form isn't service.
Understand.
That's
completely.
understood. So we would frankly be in exactly the same position. You know, all that would sound in my Lord and my respect submission is the exercise of the court's discretion.
Yeah, that's
What
why
you would say.
that's why I'm
Of course.
putting it.
My Lord, I absolutely understand that. Then in which case, respectfully, I have to agree that with the benefit of hindsight, yes, service of an unsealed claim form in circumstances where there are court delays might be advisable, but there's certainly no provision in the rules or currently in the authorities for that being a necessity. But I accept my Lord's point that it would be a tick in the positive box, and you let the claimant know, the defendant know what was going on. They could make that CPR 7.7 application they wanted to, and you would go, I don't know anything about it.
The judge's essential point was that your solicitors knew on the 12th of December that there was no further obstacle to issuing the claim form because the fee had by then been paid.
Yes.
And he goes on to say there was rather desultory correspondence with the court. He says it's at paragraph 36, there was a 35 to 36, that your solicitors were in contact with the court intermittently about once a month, and that after the 21st of February, when he was still in time to serve, you really should have been, if you'll pardon the expression, jumping up and down, badgering the court, saying, where is the claim form? And you didn't.
Yes, my Lord, that again, respectfully, my submission would be that goes to discretion as opposed to a duty, because one isn't in that statutory confined limit. One is simply waiting for the claim form to be issued, which is a matter for the court. My Lord.
No, because I don't think that's right.
Look.
I understood from your skeleton argument that this ground arises if you're wrong on grounds 1 or 2. That is to say, the claim form has been issued.
My Lord, understand. Then the submission I made, is simply the judge, or not that I didn't make the submission, the judge made a factual finding that the claimant had no knowledge of the claim form being issued until April 2024 and wasn't received until that date, paragraph 38 of his judgment. In those circumstances, in terms of what reasonable steps could be taken, having had no knowledge of issue, and I accept the points that have been canvassed today, that there's a claim number and so on and so forth, but again, with the benefit of hindsight, that's exactly what a claimant might have done, but actually, in the absence of knowledge of issue, you are slightly passive in that you're waiting for the court to issue and provide you with a claim form to serve it, because there is no other spur to the appellant, taking, of course, my Lord's point that it's been a long time and there have been delays.
I mean, the judge is saying, isn't he, at paragraph 38, that even if your claimant, your solicitors didn't know, they should have known, right at the end of 38, should have realised in December 23 or early 24 the claim form had been issued but not sent out. So, accepting that they didn't in fact know,
yes.
He says they should have done.
We're back into my early submissions in that they didn't know because the claim number didn't tell them, and the correspondence with the court indicated that it hadn't been issued. So, my Lord, I accept the point, absolutely. But
isn't your potentially better point that on the language of the rules, what has to be shown is that you have taken all reasonable steps to comply with the requirements of 7.5, which is actually compliance as the service of the form. So whether or not you took reasonable steps to find out whether there was a form or anything else, you would say is not to the point. The question is, what could you have done to comply with a requirement that you serve within 4 months of issue in circumstances where you haven't got a document that you can serve at all?
And no knowledge, I'm very grateful, my lady, that was exactly, probably not as articulated as my lady has, but that was the point.
I mean, that seems to me at the moment to be the strongest point you can make under this head, is how can we take reasonable steps to serve something if we haven't got it, we don't know it's been issued, and we can't serve it until we've got it?
Yes, my lady, that is the position reached by the judge in paragraph 33 of his judgment for Bundle 68. And that respectfully is difficult to reconcile with the CPR position. Reasonable steps can only be taken once a claim form has been issued, by which I mean provided to the claimant to serve it, or as in the Rogers case, where there is knowledge that a statutory deadline is about to be missed. There's no such statutory deadline here because we canvassed the starting gun hadn't fired, or at least my client had no knowledge of the starting gun being fired. And the judge accepts in 33 that the claimant can take no steps to serve before the claim itself was issued.
Well, you're saying you couldn't take reasonable steps to serve until you got it. I mean, forget about issue for the moment.
Yes.
You can't send it to somebody, you can't serve it on somebody until you've got it. So then the question becomes, should you have done more to get it? And is that relevant?
Yes.
And I think what the judge is saying is, yes, you could have done more to get it. You could have done more to find out what the position was, and you could have done more to actually prompt the court to send it to you, except for sending a desultory correspondence once a month.
But my lady, in circumstance where the judge made a finding, my client had no knowledge until April 2024. So my lady's quite correct, but equally, those points apply, putting aside the help fees receipt, those points would apply at any point in the previous year, probably my Lord Justice Coulson's point, that the claimant could have done more to agitate in July of 2023, potentially, as well, because the claimant had no, it could have been issued at any stage, even without the help for fees application being resolved, presumably. The claimant simply didn't.
I thought you'd already accepted that you can't issue a claim form
Well,
until you've either got a waiver of fees or the fees have been paid.
Yes, my lady, but I'm making the point that if the claimant had no knowledge of when the claim form was actually issued, it is very difficult to know when to take steps, and I take the court's point that he should have known from the date of the receipt, but for the reasons I've already canvassed and won't bore the court with any more, there were indications from the court that it hadn't been issued, and it was reasonable for my instructor solicitors to not take those steps in circumstances where the court itself wasn't aware of the issue. Just to again make good that submission, I think I need to. In Rogers at 35 and 36, authorities bundle 12, which we looked at earlier. You had my submission that the deputy judge's contention in Walton that reasonable steps could only be judged once the sealed claim form was in the possession of the claimant, my lady's point, and that finding wasn't overturned by the Court of Appeal in Walton, so it's the penultimate sentence of 35. And the issues that the judge in this case addresses at paragraphs 35 and 36 of the judgment are reasonable steps to try and get the court to issue the claim form itself, not reasonable steps to serve the claim form, as my lady has canvassed with me.
But wouldn't reasonable steps to serve the claim form include putting yourself in a position to serve it, like getting the court to send it to you, or, as Lord Justice Coulson said in Rogers at 43, actually turning up at the court? Maybe not on a money claim online, but in other cases.
Well, that's in the context of planning statutory view and the reasonable steps. I mean, I won't labour the submission that my solicitors didn't know that the starting gun had fired at this point. So the reasonable steps, yes, there's a lot that could have been done had they had knowledge, but in the absence of knowledge, it's difficult to outline what one could reasonably do, not knowing as I think everyone accepts.
Well, I thought the point you were making was that until you got the claim form, there's nothing you can do.
Yeah.
I'm just asking you
There's
whether
nothing, but
putting yourself in a position to serve it, by getting it, is part of the reasonable steps
to
serve.
To my lord's point, had the court said had, for example, notice of issue been sent to the claimant, but the claimant not having the claim form, then the claimant would be on notice and would then reasonable steps would start. But
So it goes back
it's
to
circular. I understand that.
knowledge.
I understand that.
I understand.
And I made the point already that absent that knowledge, you can't make applications under CPR 7. I think the only other point is just in the judgment, there's reliance on my Lord or Justice Coulson's footnote in Rogers about making applications for extensions of time before the form comes out, but that's in the context of planning statutory review, where there is a hard deadline that you need to meet. Here, that it's not so in a standard claim where time to serve only begins on the issue of the claim form itself, for which they have no knowledge. My lords, my lady, those are my submissions, unless I can assist any further.
Right. Well, that's very clear. Thank you, Mr. Fry.
I'm grateful.
Thank you very much. We'll rise for a couple of minutes, but don't leave the courtroom, please. We'll be back shortly.
Still recording?
Yeah.
I won't make jokes then. Did you see me wheezing?
Later, leave court then after you very
Difficulties.
And the thing this is whenever you protect imitation in good faith orders, notice of issue.
Yeah.
It doesn't have the service dates. Keep all these it's the big issue.
You didn't get it because of the way it came out.
So if you look, we always diarise asking deadline for it. That's one thing in CPR. Maybe tribute to it. But that's the general procedure. They're protecting imitation. Notice of issue.
Yeah.
To us.
Yeah, you can, I think they've got that. Yeah, there's notice of issue. How do you know? If you get notice of issue. Yeah, yeah, they did. We discussed those issues. I'm sure. So there's no issue. Because it all came out. It all came out through the complaints. That's the issue. One department government. Another is that you can't rely on complaints in the court system. Take the home office. It's good for the goose, it's good for the gander. You can't say, well, CTMS doesn't know what they're doing. I said, I think losing sounds like No, was. There are difficult facts because the year delay. In the Couriers, we took payment, couldn't take payment, they wrote to us. We say, should you have written every day potentially? So anyone who deals with court knows that it goes nowhere. Yeah. It's the problem with one doesn't know what experience is. And this is happening over the place. Of course, just sitting on documents. I didn't think of that. If you're an accountant for that, you're going to have to always, if I wrote, make an application for extension of time. Because contribution, I suppose you'd make it for 3.5 months after you filed the claim. I don't know what time you can have an extension time, which might be respectful reasons. No, it was yeah. Let's see.
So it was something in February with a phone. Why you mentioned specifically.
I see what you're saying.
Do the best.
It's worth taking off and see what you more questions for me. Back to me. Page 31.
Mr. Tobin, we needn't trouble you. The appeal will be dismissed for reasons to be given later in writing. When you receive a draft judgment in the usual way, it will of course have the embargo, which means what it says, so it can be distributed only to those on the distribution list. We would hope that in the light of the draft judgment you will be able to agree an order disposing of the appeal. But if you can't agree an order, please make short written submissions and we'll make the order that we consider to be appropriate. The judgment will be handed down by electronic means and released to the National Archives, so there will be no need for any further attendance. Thank you very much.
Well,